All right, so H-1B second round of selections have been announced by USCIS on Thursday the 27th, and much expected, no surprise there. What is surprise is the amount of selection that we're seeing coming through, and they're not done yet. I'm Sam Shihab with Sam Shihab and Associates, and with me,
Brian Burke, also Sam Shihab and Associates. You know, what else am I going to say to that, Sam? I don't know.
That's right. Well, that gives you flexibility.
Yeah.
We are immigration attorneys. We practice employment and immigration law in the U.S. and throughout the world, stationed here in Dublin, Ohio. And we spend every week 6 o'clock Eastern time for 1 hour or thereof, a little bit less, a little bit more, to talk about a pressing issue or an important issue that occurred in the prior week and answer your questions. And so this is today's topic, H-1B cap, second round of selection when we come back. Okay, so obviously we're expecting it. It's not a surprise.
Well, nobody knew for sure. But people were asking us during our chat sessions here, and it's probably going to be sometime in the month of August. I guess they beat us a little bit before the month of August, but I guess that means they're being extra efficient in the cases that they had, or maybe Sam, it was because they just didn't have that many cases thus far, and thereby they could get through them very, very, very quickly.
So there's a lot of chatting and sharing of information everywhere around, and somebody is throwing out the number of 15,000, perhaps upward of potentially 20,000 selections. We're seeing a large number of registrations for sure coming in our office with relative to prior filings.
Yeah, I mean, quick and dirty numbers, but realistically I was seeing, from clients who registered more, who will probably be a better data set, getting about 2/3 of what they got in the first round of selections, which is huge.
It's massive.
Yeah.
I mean, if it's 2/3, that's even more than
yeah, I mean, to give the audience insight, I'm thinking, well, I guess I'm going to be doing a lot of H-1B cap cases in the the late summer and into the fall as well,
And so if, I'm going to start with the right question, with the critical question right out of the box. Okay. Let's assume that the number is 20,000 or 25,000.
I'm inclined to believe something so high, yeah.
Let's assume that's the number.
Yeah.
Does that in your mind confirm that we have at least 25,000 questionable prior H-1B filings?
Well, I think questionableness is in the eye of the beholder. And one of the things that we've been
the question is in the eye of the beholder, according to USCIS.
Well, okay, so USCIS says yes, rampant fraud. However, I don't think there were 25,000 cases denied by USCIS due to fraud. They have said, and I have no doubt that they did, send out some notices to companies saying, "Oh, baloney. We've looked up your company. We've looked up, these companies we believe are related. We've seen people. We've been asked to consult on those sort of, from people who we don't usually do business with. But employees of companies like that have come to us saying, "Hey, what's your opinion on this?"
But there's a lot of cases are not rejected but not filed because of fear.
That's my point. That's my point. And I guess this is when I make that public service announcement again. An individual is allowed to be in the cap through multiple companies, for sure. Only they get in trouble if they're engaging in a coordinated effort with a registrant to artificially increase their chances. But the bottom line is somebody can independently have hypothetically 3 job offers from 3 distinct companies, offer them 3 distinct things, and that is perfectly allowed under the H-1B rules. Agreed?
Yes.
Yeah.
And companies, per the regulations, there are circumstances by which multiple registration is clearly permitted.
Yeah.
Per the regulations. So I think that's probably lead into, I'm jumping around here too much, lead into the conclusion that we might not see as many as criminal
The criminal referrals, which
referrals,
they refer to.
because once the research is done by the criminal attorneys, they may conclude that it may not be.
These cases may not be good in the government. They're not worth prosecuting by the government, and that is something I am desperately waiting for. Because one of the questions, that I had on my list for today is, what has been the progress on those fraud investigations? Because those fraud investigations are inherently related to the second round of the H-1B cap, because that fraud has scared people off filing, yada yada yada, etc. And the criminal referrals, I've been on the lookout. I guess it's possible that I might have missed one, but Department of Justice loves to put out press releases when they go after some sort of criminal wrongdoing in immigration matters, and I monitor those things.
When they press charges, though.
Yeah, when they press charges, and I have not seen anything like that yet. I review them periodically, and of course I look at the news because all of my Google News alerts are set up to capture those things. And of course I did a search right before this presentation. Not a peep. No criminal charges yet for anybody in these alleged H-1B fraud registration cases.
And a lot of these non-filers, companies that decide, hey, I'm not filing these cases because my sister company filed them. They could be legitimate cases, duplicates, but a lot of people are chilled. There's a chilling effect from filing. I mean, we know companies that are 100% by the book. We know that because we're very close to them and we manage their filing, and they're very much in touch with us on every step they go along the way. Even these companies are saying, yeah, I know, but this guy told me he filed with other companies. I don't want to file these cases.
Exactly. So I guess it's not only a chilling effect on the individuals, it's a chilling effect on the companies.
Even the good companies, even the good guys now are saying we're not going to file as many cases because...
Yeah, all it takes is to, the worry is, okay, so if they found this person filed for 4 companies and they filed for my company, I don't want them, grasping at straws, trying to come up with some artificial way that I'm related to those,
I don't have to waste my time on this stuff. Forget it.
It's
about
scary stuff when they're talking about criminal referrals. So no progress there. And Sam, I'm itching to read those court cases because I want to read the government's theory as to how some of these things can be considered criminal, because I've expressed this before in this venue here, that I think that they're going to have some serious challenges in proving the criminality of
a lot of these activities. Yes. All right, sounds good. So good news. A large number of new round has started. The government has not told us that they have stopped yet, so they are continuing to send out email notices.
Point. Yeah. So if anybody who's gotten a receipt notice, a new selection notice, can see that the filing window begins on 8/2, meaning they could still be squeezing in additional selections or just notifying more selections through tomorrow. So I guess until you see that email from USCIS saying they've completed the second round of selections, you don't know for sure. Then that.
What's a new filing window, Brian?
As I recall, well, Sam, I know I put it in my notes here, but I can't remember it. So it's 8/2 until 10/31, as I recall seeing there.
Okay. So October 31st.
Yeah.
Okay. So now, that's beyond
the H-1B start date.
H-1B the start date. Now, how confident they are that they're not going to need a third selection?
So that's something I wanted to bring up because Sam, hypothetically, if USCIS has 25,000 slots left in the cap they haven't used, how many new selections do you think they do to cover that?
I don't know.
Well, do you believe it to be more than 25,000?
Well, I mean, we don't know whether they have 25,000.
Well, just hypothetically. Well, how about this?
Assuming.
And when they make the selection at the beginning of the fiscal year, when they first start making selections, they have 85,000 slots to fill, right?
Sure.
And we know, or we know they make more than 85,000 selections to account for people who don't file, denials, and flow over from last year. So basically, I mean, we don't know exactly how many they pick, but somebody.
Oh, they did announce 97,000 or something.
It is? Did they announce 97?
Yeah, 97,000.
Well, there you go.
Yeah.
So I guess one thing I do want to point out here is, eventually, it's possible for them to, let's say, misrun those calculations, and that's
Well, yeah, because a lot has happened.
Yeah.
And a lot of these people have gone in different direction, went back to school.
yeah.
Some people applied for O visas. Some people left the country. Some people changed employers. And we're going to talk about those scenarios. And so a lot of people, and then some companies' business need have changed.
Yeah, that's a very good. Well, for me, the thing I like to bring up is that USCIS generally takes in more cases than they have slots for. And I guess I would say generally a good rule of thumb is get your CAP case in and any RFE responses in sooner rather than later, because at the very tail end of the H-1B CAP season, you see some funny arbitrary H-1B denials, and I always suspect those are results of them not because not ineligibility, but running out of cap numbers. So get your cases in sooner rather than later, because they take more cases than they have slots for.
So I'm going to come out and say that a third round of selection is very likely.
You think?
To occur. Yeah.
Well, I guess the same factors are at play here.
Because I think a lot of these are not going to get filed.
I guess I fully agree with that. My only counterpoint to that would be if they did a massive, if they know that now that a lot of people won't be filing these.
But how do they quantify it?
How do you quantify
They
it?
cannot oversubscribe.
They do. I mean, to some degree, to account for denials, people who don't file, et cetera. So they basically use up all 85,000, and some of those in the past, I'm pretty darn sure, have resulted in arbitrary denials that weren't really merited because oops, we ran out of numbers. So but you're right. It's really hard to quantify how many people aren't going to file, and thereby it does create the opportunity for a third round, which makes you wonder then when would that happen, Sam? So basically, the filing deadline for the first round was 6:30, right?
It should be about 3 to 4 weeks after October 31st.
So Merry Christmas, happy it's realistically going to be in November then? Maybe early December, where we hear about a third round?
November, I would say.
Late November, early December.
Yeah.
Yeah.
It's going to be November probably, because October is the filing date, October 31st.
Yeah, late. And they're going to need time to basically take, did we get all the cases we need after that?
So maybe 4 weeks, maybe, it'll be maybe the early December.
Yeah.
Yeah.
So that's, fine, I guess, but it is what it is. Interesting times. It's just realistically now, Sam, they did the second round in December, 1 month in January, 2 months in February, 3 months in March. We could find yourself realistically in a scenario where we're preparing for the next year's H-1B cap when we're still closing out cases, filing cases from the prior fiscal year.
What a mess.
Which is not something we've seen for quite a long time. I remember maybe 2015, 2016, maybe 2014, something like that, having cap availability well into the next fiscal year, January, February, but it's that was due to economic downturn historically.
So we got a bunch of calls.
Yeah.
People asking us a lot of questions,
Sure.
and I think we kind of put together an assortment of what we see a lot. One of them is, I went back to school, okay, and now I am on CPT, okay, and I just got selected in the lottery. Shall I quit my CPT and go to school?
Well,
and get to H-1B?
For me, that answer is pretty simple. It's first of all, no.
Well, either yes or no.
No.
Okay, don't
I
quit.
said no.
So don't quit your CPT and don't file your H-1B. You get selected in the cap.
Well, if you're selected, it depends upon if you're. If you're selected in the cap, that's not enough. The company has to be willing to sponsor you.
And willing to sponsor me.
Yeah. So you can't quit your CPT. Well, I guess the CPT is not necessarily a requirement for anybody to maintain their F1 status. But if you have CPT and you'd like to maintain your employment, keep going with your CPT, because that.
Let go of the H-1B selection.
I'm not. If you're there,
that could be once every 5-6 years.
No, these things aren't okay. So if you're selected in the lottery, go ahead, file your H-1B cap case. I'm just saying, maintain your CPT until October 1st. Sorry, that's what I'm saying.
Yeah. The question is, do I forgo the H-1B and continue with my CPT, or file the H-1B?
Depends upon your personal circumstances. If you have worked, if you entered an advertisement saying, "Hey, we're going to register you through 5 different related companies," well, say goodbye to that H-1B lottery, because I don't think I could, in good conscience, recommend it.
So step number 1, confirm that selection is a solid selection.
Yeah.
That's step number 1. If you are on CPT, because you have options, okay, ask for straightforward question from that employer. Have you multi-filed for me? Because I don't want trouble.
Yeah.
Okay, and then ask around, and find out what's the word on the street about the company. Maybe you have a good relationship with the company and you trust them, right? Then, if there's any problems, don't touch it. But if there is no problem, file for it.
Yeah.
And don't quit your CPT until the H-1B is approved.
Yeah.
And then you're beyond October 1st,
Yeah.
obviously.
You have to maintain your F1 status through the date of your H-1B approval. Yeah.
If you find out that the H-1B employer, or that would-be H-1B employer, has problems, has a history of multi-registering, which means that registration is going to bring you more headache than necessary, then don't do it.
Yeah.
Okay. So that's the shall I quit my CPT? We got some people who got filed for O visas.
Yeah.
Okay. And now they got the opportunity to file for H-1B.
Yeah.
Well, number 1, O visas and H-1B visas are not inconsistent.
Yeah.
Okay, you can continue with the O visa, and you can still file an H-1B visa.
Yeah.
If both are approved, which one would you go with?
Well, if both are approved, I'd say congratulations, you got approved for an O visa, and stick with it. O visas don't have a cap, and they have loftier requirements, and I don't know. I like my EB1s to be on O visas. It makes a nice, good story.
What about changing employment?
Change of employment? Well, okay. So
we visit the O visa every time. It's a pain.
That is true. Well, O visas are for basically people at the top end of their field. But I guess if you had a marginal, okay, you've changed the facts a little bit. But if you had a marginal O visa case and you sort of think you got through by the skin of your teeth, you'd be foolish to.
Well, the one suggestion you gave me earlier is file the H-1B in counselor notification, and then file the and stick to the O visa, and if the O visa, for example, for some reason is problematic, you can jump back on the H-1B visa, right?
Yeah, that is true. I mean,
obviously, if you file a non-counselor notification, you're still subject to the cap. You have to go in, interview, and get stamped.
No. I have actually had this exact scenario play out. Somebody who basically lost their sort of, anybody's willingness to sponsor an O visa for them, because they are more complex visa applications, and talking for a while. So, you ever been on H-1B status before? Oh yeah, for a little while. Bam.
Back to H-1B.
Yeah, H-1B, that can save somebody's
That's beautiful.
butt. Yeah.
Okay.
Yeah.
Okay, great.
Yeah.
So consult with your attorney on the O&H visa, and you don't necessarily have to make a selection. You probably can maintain both of them, or at least keep them alive for as long as possible to give you flexibility in the future. So that's the one that we tell people. The real answer, like you said, is really on a case-by-case basis. But if you can throw in the H visa, file it, get a counselor notification, and get the O visa going. Now, if you do a counselor notification H visa, can you transfer to a new employer?
No. I mean, technically, the way the rules read is that you have to get that status, visa stamping.
But a lot of time they have approved them.
Yeah, this is very true.
They have approved them without giving you a hard time. I mean, their flexibility.
If you got, I mean, if you got an employer who H-1B visas are hard fought. If you can get one, I'm all in favor of it. I mean, I can give you the.
It's easier to get.
I can give you the entire flipped answer. You're registered in the lottery. File that H-1B visa, get on H-1B status. I think any employment-based immigration attorney worth their salt can evaluate your job description and your credentials and tell you pretty darn quickly whether or not you can get an H-1B visa approved. Whereas an O visa, give me a couple hours and I'll give you well, maybe if these things play out.
And the reality, I know O visa does not have a limitation.
Yeah.
But the H visa doesn't have limitation either. Let's face it. Once you file that for that labor certification, You have indefinite.
yeah.
I mean, who is stuck with 6 years anymore? Nobody's stuck with 6 years.
Yeah, that's a very good point. Maybe people have gotten better about, employers as well have gotten better about doing it, but fundamentally, you know, when I was shiny and new at this job, I feel like I spent a lot more time on worrying about people at the very end of the H-1B, 6 years, trying to get a perm and I-140 approved for them. Whereas as of late, I guess people have been punished by the long and ever increasing processing times for perms and perms really for the last couple of years, and I guess they've kind of gotten started earlier and earlier.
I got contacted today with a client saying, I got selected, but I changed employers. Can you please help me transfer my lottery selection to the new employer?
Well, I'm going to imagine your answer. It's probably with a concerned, sorry, that's not possible. Which who knows if they make a change to the lottery in the future? It might be, but unfortunately, right now the selection is owned by the employer. It belongs to the company. You can't change it.
I'm going to say something here, slightly impolite.
Yeah.
How stupid of a system is this?
So I've had.
How stupid is this?
That it's controlled by the employers. It opens it up
Not
for this
being
sort of
transferred to another employer who is willing, ready, and able, and capable for the job and the specialty occupation to hire this guy.
So I have thought about this and the concept that the H-1B cap should be, have the individual toss their name in, right? The only problem I see with it is everybody out there is going to toss their name, even those people who wouldn't remotely qualify for an H-1B visa, and then it's a scrambling search for a job. So how do you manage that process where the individuals can control it?
Well, it's not being managed now anyways.
Fair enough. I'll give you that point. It's an absolute mess with 12 different rounds. Yeah. I just imagine just people without the credentials, without any sort of job prospects. I think
the idea that the employer controls an application for a prospective employee, not even an employee.
Yeah.
Okay. Is wrong.
Yeah.
It's wrong. So that has to change if we are going to have a system that works in the country. It doesn't make sense. This is an old 1990s. This is prior to this century.
Yeah.
Rules and common sense. It doesn't make sense today. In today's world, I got my degree, I got my education, I must own my opportunities. The idea that an American employer controls me is ridiculous.
Well, yeah, but see, it's kind of funny though. As soon as you're selected in the cap, you've gotten into the lottery. The H-1B, you still have to have an H-1B employer sponsor, but the cap accounting is yours as soon as your employer gets it approved for you. You can jump whoever, anybody willing to file an H-1B.
Why can't it be done before?
And
there's no policy in support of that. And you agree?
I do, but I mean, I just say, but I imagine, that they'd get just unvetted. If they did it, I guess you have to really come up with a new lottery system. Basically establish some sort of prospect in the United States, have some sort of offer or something.
So one of the people contacted us and said, hey, I got still 2 years on my OPT.
Yeah.
I just got selected in the lottery. I'd like to drain my OPT before I jump on my H-1B. Would you recommend it, and how to do it? First one, would you recommend it?
No. There are people, somebody out there in the audience who is screaming at that person saying, give me your H-1B cap selection, because that time is hard. That H-1B cap
How about if you do consular notification and keep the OPT, working on OPT?
So here's my problem with that. So you're not considered officially counted against the cap.
So you don't have to worry about prevailing wage, you don't have to worry about work location, you don't have to worry about public inspection files, and then you send it I-797 for consular notification for another year and a half. When you go visit at home, you go pick it up and come back.
That all sounds great for the employer. Don't having to worry about LCAs, MSAs, wage rates. But if I'm the individual, how do I know I'm going to get lucky in the next 2 years?
Good for the employer, not good for the employee.
Yeah, I mean, don't get me wrong, Sam. I've encountered the occasional employee who wants to do this, and basically I say, you're only increasing the chances that you never get on that H-1B status, never get considered counted against the cap. I mean,
that's an excellent point.
Yeah, that's what worries me. Yeah.
I'm outside the United States. Just got contacted by my employer. I am selected. What shall I do? Can I come back to the U.S. now that I'm selected?
Not that you're okay. Yes, but eventually. We've begun the new H-1B cap. New filing window begins immediately. If you're outside the United States, you can't request parole or something to enter before your H-1B cap is approved. I think that's kind of the question we've had. It's is there any way that you can get me there before the October 1st date? And the answer is no. It's unfortunately you have to go through the consular process, which the big old challenge that comes as we approach October 1st is those consulates get quite busy by virtue of just the demand for new H-1B visas. That's the problem.
The last one we got a question on the other day is, I have been selected in the lottery. I know it's going to take 6 or 7 months for me to be selected. I'm on a student visa, OPT, right now. My employer is anxious to get the prevailing wage filed for the green card. Can I get it now before I get my H-1B? Can it affect my H-1B? And is it advisable if my employer is willing to start my green card process now?
Sure.
Because it's taking forever.
Go for it.
Is that a good idea? Is that a bad idea? Pros and cons.
Pro. Go for it. Go for it. Good idea. Good idea. Get yourself in an earlier priority date. Get yourself on the perm process faster. Okay, maybe some cons. So I'm not really seeing the cons on that, Sam.
So the negatives are extremely limited if non-existent.
Yeah.
Just be aware that the labor certification process, you have to file a labor certification prevailing wage, which takes about 5 months, 4 to 5 months.
More like I'd say more like 5 to 6 now. I think it's come down just a tiny bit. So.
Yeah. To get that during that time, there is no conflict with your F1 status. When you file the labor certification, also there is no conflict with your H-1B status.
When you get to filing the I-140 with USCIS, that's when they can,
But that is a long time.
Yeah, and I mean, how long does it take to get to the I-140 filing stage at this point? I would say
18 months?
Yeah, easily. Beyond that, probably.
So start now, it's not a bad idea.
Yeah, I mean, it used to be, before the perm process, maybe like, say 5 years ago, that we'd say, be careful, starting the green card process while you're on student status, because eventually you're going to hit a point where it's going to tell the government you have immigrant intent. And if you're not on H-1B at that point, you're going to have a problem. But with the let's call them long, luxurious perm processing times, hasn't really been an issue. And as long as if you're selected in the lottery in March, I'd say as long as you think you have a solid H-1B case, get started on the perm, the green card process. Yeah.
All right, so those are the issues and the discussions on the H-1B second round of selections. I hope this was helpful. And when we come back, we're going to be answering all your questions. All right, folks, this is part of the presentation where we answer your questions and bring them in. We're going to try to answer as many of them as possible and hopefully give you some guidelines. And just a reminder, do not rely on the answer because we just said a very brief response to a very brief question. There is not really enough information to give you enough advice to really to make a decision on your case based on what we will say here. So there's no attorney-client relationship is established. However, we'd love to answer your question, give you some guidelines to give you at least a flavor of what you should be looking at. Yeah. And without further delay, Nepal 123 got a question for you, Brian.
Yes. Nepal 123. What will be the final action date for EB2 Rest of the World in October Visa Bulletin, if you have to guess? Thanks so much. Nepal 123. I can't help but wonder why he's asking about the rest of the world. I can't help but think that he might be born in Nepal. So, first, I'm going to give my disclaimer that if I've given up on predicting specifically the visa bulletin in general,
you've been humbled.
I've been humbled by the visa bulletin. For I say left, it goes right.
It's a beast.
Yeah,
controlling a beast is impossible.
Yes. However, There's this lovely thing here called the dates for filing, which I can't help but see that you're looking at them too, Sam. What do you think about the dates for filing for the rest of the world in October, Sam?
Well, it's saying December 2022, Brian.
I can't help but think that sometime that we're going to see something along the lines of December 2022, at least if not in October, sometime during the next fiscal year. And I guess October is really the best time. That's when they have sort of maximum visa availability in their eyes, at least. Yes. Yeah.
Brian.
So from Manas Parida, my spouse works on H-4 EAD. I-94 expires in July 2024. If I file her H-4 and EAD extension, and if it is still pending beyond July 24th, can she continue to work? Ooh, this is a great question, which I don't think we've gotten in this venue before, which is literally a question that I can sometimes ask, answer for people like 5 days a week. So I would encourage everybody to go ahead and read the rules on the automatic extension of EADs. If you just do a quick Google search for that, USCIS has that information online. And the executive summary, the thing that you have to look at, Manas, is that the H-4 EAD category has an additional requirement for automatic extension of EADs, is that the H-4 EAD holder must have a valid I-94 in hand in order to be eligible for the automatic extension, which really kind of takes the teeth out of the availability of the automatic extension. So I see a problem with Manas' scenario here, and that he's saying if I file an H-4 and EAD extension, together, that's for me is gonna say, well, it says it right here. If you're filing an H-4 in the I-94 expiring in July 2024, your spouse is not going to have an I-94 that goes beyond then, meaning she's not going to be eligible for the automatic extension of the EAD. Sam, what is the kind of remedy you think of to overcome this scenario?
Leave the country and come back and get a new I-94?
Yeah.
Is that a good idea, Brian?
I think that's a great scenario. So basically, Manas, maybe you file your H-1B a little bit earlier than July 2024.
In premium processing?
In premium processing, indeed. You get a nice shiny approval notice. Your spouse uses that shiny new approval notice as an excuse to take a trip, presuming that she has a valid H-4 visa first, and comes back with your I-797 that goes through presumably 2027 with your visa stamp, and gets a nice I-94 that goes through July of 2027 herself. And then
you timely file the EAD extension, and then you take advantage of the automatic extension, which gives you work authorization for how long, Brian?
So we have to start. There is a 180-day extension, and there's a temporary extension of that to 540 days, I believe it is. That 540-day period is coming to an end. I believe it's in October, and that's why I would encourage everybody to not listen to the words that come out of my mouth, but instead just do a Google search for USCIS automatic EAD extension, and they have a very detailed website on that.
Yes. All right.
Literally just answered a question about that 20 minutes before we started here.
Yes. So our friend here, Manya, if I can get that screen bigger, Brian, because I cannot see.
Yeah,
thank you so much.
We reload our questions.
Yes. Are there any, so this is Stats Mania. Are there any possible sanctions from USCIS for colleges that enroll students with pending I-45? Well, I'm going to give you the short answer and then a little bit longer answer. There is not a possible sanctions from USCIS. In fact, people with pending adjustment status 100% are allowed and legally permitted to engage in studies, and if they have EAD, a lot of them have EADs, to enroll and work, and if they have advanced parole, to travel, and to take part-time school, full-time school, part-time job, 2 jobs. The absolute full flexibility between the EAD and the advanced parole, and the fact that they have an I-45 to engage in about any activity in the U.S. Open a company, run a business, go on vacation, except obviously the only thing is to vote on property, sell property, manage property.
Yeah, certain things. Here, own guns, Sam. I'll give you another one. There's a lot of things.
Yes.
Things people who are foreign nationals aren't allowed to do in the United States. But yeah, generally speaking.
I think you might be able to. I don't know if you filed the proper paper with certain states.
I've had to research that before. I thought it was a problem to possess guns as a.
I don't think so.
Oh, okay. Well, I'll presume
as a blanket prohibition, no, there isn't. As a matter of fact, if you are, but we're not answering that question.
Yeah, exactly. That's just me. Yeah, that's just me talking.
Yes.
Yeah.
All right, sounds great. So going to talk to San. Brian, you want to take that one?
Yes. So last week you said you answered my question this week. Here's the question: is it legal for an H-1B holder to invest in a publicly traded cannabis stocks listed in NASDAQ? So we spent a little bit of time looking into this after we talked, and I think it falls in the category of there isn't a 100% clear answer on that. And for me, my first, if anybody asks me that question, I'm going to say avoid it with a. Yeah.
So there's not a question on the. I mean, your activity is not illegal in the U.S.
Yeah. Well, illegal is a different question as to there's whether it's illegal, and the answer is no.
Yeah.
But whether it is an immigration problem is really kind of the fundamental question.
Well, I mean, with adjustment of status is you got inadmissibility.
Yeah.
And you got deportability, right?
Yeah.
And then I think that we're looking at these adjustment questions.
Yeah.
We haven't seen anything pinpoint to that, although I think the consensus that we have seen is that avoid it.
Yeah, I mean the questions that we're talking about here for Talk to San is if you look at Form I-485, the green card application, there's questions such as, have you ever knowingly aided, abetted, assisted, conspired, or colluded in the illicit trafficking of any illegal narcotic or other controlled substance? And even though those companies are more or less legally operating, certain drugs are illegal at the federal level and are considered controlled substances, and that's the question that's out there. And I think that that by buying a stock that is not giving money to a company, I think you could make an argument that say, well, I haven't aided or abetted anything. I just basically bought a security. However, I mean, there's a question of have you benefit it from it, and that's one where does that stock pay dividends? Do you make money when that company does well? Those are the sort of questions where I think, in theory, you can get into a complex argument with USCIS. So, never. I don't think anybody can give you the definitive answer as to whether it's how an individual USCIS officer is going to act on that. But basically, my humble advice would be to play cautious. For me, as an immigration attorney, when I'm playing with somebody's life and future in the United States, I say figure out where the line is and take a step back from it, because I don't want to. I guess fundamentally, I never want my client to have an interesting immigration case. Something that makes the officer say, "I'm going to have to go research that or talk with my supervisor about that," because that's fundamentally it for me. I don't want a complex,
It's a $1 billion industry for people that don't know what it is. So there's not a documented case on this, and because of that, honestly, we cannot give a clear answer. But I don't want to be the first person trying to save somebody's green card.
Yeah. Well, you know what, Sam? I do want to be the person. I do want to be the first person. I want to be the person trying to save that person's green card, because I think there's some great arguments you can make. However, I don't want to be the person. I'm definitely not going to be the person who advises you go ahead, buy cannabis stocks, because find that line and just stay away from it.
Yeah. Lost 12.
I like this question. Hello, Sam. Hello, Brian. Now, since there's no more employment green card for this year, does it mean USCIS will go on vacation, or are they going to try to reduce AP processing time?
I think on vacation is the answer.
Well, Sam, I have a funny little anecdote. I was traveling in the Midwest about 2 weeks ago for a green card interview, and I was at a local USCIS field office, and an officer, very strange, came up to me and said, hello there, attorney, can I ask you some questions? And strangest interaction I've ever had. I was just hanging out in the lobby with my clients, but I said, sure. And so, I had maybe a 10 to 15 minute conversation with this officer, and basically he explained, hey, we're trying to get our processing time frames down on everything where we're going here. And he was asking me about, like, what are you seeing on processing times for X, Y, and Z? Because he was genuinely curious as to if they're getting any faster. So I don't think they're taking a vacation. I know that USCIS has done a bunch of hiring in the last year, and some of that has to be in the service centers, and some of that has to be for people who are processing advanced paroles. Anecdotally, I have seen their new hiring, Sam. I was once in an interview maybe about 6 months ago where there was me, my client, and 4 other USCIS officers in the room. One officer giving the interview, another supervisor, observing the interview for the purposes of training the 2 other new super officers that were in the room. So they are hiring people. If your guys aren't aware, I think it was at the end of either the end of 2022, they had a big hiring push where I think that they hired, I can't remember the number, but thousands of people. So in theory, those people are getting trained, they're getting up to speed, and they should be able to process APs faster. That being said, we haven't seen it. I haven't checked the processing time for an AP in the last couple of days, but anytime I've checked AP processing times as of late, it usually I'm in the context of a consultation with the client, talking about maybe filing a family-based green card, and I'll say, okay, we're also going to file some interim benefits for you when we file this thing, and how long it might take to get those, and I go, okay, well, I'll tell you this, I was going to tell you anyway. But you're looking at a better portion of a year, and I tell people realistically anymore when it comes to filing a family-based I-485, realistically we're going to file these things for you because it's our job and we want you to get them. But realistically, you may see an approved green card before you see your EAD and advanced parole, and they'll disclose them when they approve the green card. So I am hopeful, but I guess I have skepticism as well.
VJ Garage. My son has got his green card a couple of weeks ago. Yes. Whereas primary applicant still pending. Dang. Is this normal? Anything I need to do to push my case? Well, no, it is absolutely not normal, because technically speaking, your son, if he is a derivative to you, should not receive his green card before you. It's simple as that. You must receive that green card before your son gets it.
His whole requirement to get a green card is to be related to you who's getting a green card.
Your son has to receive it with you or after you, not before you. Having said that, it tells me that that green card may be recalled, or you have been approved but not notified. Whatever it is, definitely there's a screw up by USCIS. You need to be proactive. Make sure your son does not give up whatever activities. I mean, if he's a young child, it's not a problem. But if he's, let's say, on an H-4 visa and now he's going to go work, just be careful until this issue is cleared.
Yeah, they can in theory use that against you.
They can't really.
I mean, they shouldn't, but I mean.
But let's assume he's a student and then he quit school.
Yeah.
So we don't want to do things like that right now until it's clear.
Yeah, I mean, that's the sort of thing where what would somebody do to in theory push their case? I mean, for me, contacting.
This is a congressman immediately.
That's on my list as well. Contacting USCIS, contacting a congressperson, anywhere where they're going to. Yeah.
All right, sounds good. So we got a question here from Fort Myers saying, hello, Sam, Brian, thank you for everything. Well, we appreciate it. Can you please give your estimate about EB3 other workers visa bulletin priority date in 2021 November?
So
okay, thank you. So I think what we can do begin by looking at what we think in October is going to look like the rest of the world. So what we're seeing here that
the other workers,
May 2023.
No, he said other workers, EB3 other workers. So
okay, so June 2020.
Yeah, 1st of June 2020. So, and he's trying, this person, or he or she is trying to get to November 2021. And so when we see the dates, I guess when we see the dates for filing, being in 1st of June 2020.
It's not. It's very narrow looking. They got it here, the window of 1 month only.
Really?
Yes.
That's interesting.
Yeah. So there's not much left, and it's not moving forward.
Well, so again, this is where I guess I haven't been paying attention to the other workers category very much. This is where I get confused and concerned about the visa bulletin in general.
Well, there is a piece of information about other workers category, Brian, that we should share.
Yeah.
It's only 10,000 green cards per year.
Yeah.
It's limited every year to 10,000 green cards.
Yeah.
And then you work your way into the 7% per country. But if you're not from China, India, Mexico, or Philippines, and you are all chargeability countries, then you're looking at decent number, but not as much as the third preference, professional, second preference, or first preference. And because of that limitation, it doesn't move too much. And right now, the government is telling us that they don't have a lot, and they don't expect it to move forward too much.
Yeah, I wonder if I still have that. I don't have it up anymore. It's a shame that I-140 backlog chart. I wonder if I still have it downloaded here. Basically, the USCIS inventory of I-140s waiting for a priority date. That might give an interesting insight for somebody. And I still have it saved here. So here it is. Rest of the world, EB3, other workers. I mean, there's a. Well, here's your answer, Sam. The rest of the world, per this I-140, this report is of I-140s and other immigrant petitions.
As of March.
As of March of 2023. They say the rest of the world has 11,829 people waiting for a priority date to come up, and if they get 10,000
per year, yeah. The other chart has the allocations.
Yeah, I don't think I have.
Excel.
I don't think I have that.
It should be downloaded.
Oh, yes, I do. I do have it here. There it is. Let's see if it's the right one. Visa allocation, and EB3 other workers. Yep, as you have in there, 10,000, and the rest of the work. Yeah.
So there's 10,000 per year. There's 11,000 waiting.
That would
explain. For it to be current.
Yeah.
So he's looking for May 2021 for 2021, November 2021. Yeah. And he's not looking for the 11,000 to be consumed, but it seems to me sometime next year he should have it.
So this is what, okay, yeah, it's so to make sure everybody understands, as of March 2023, there are 11,000 people, rest of the world, waiting for EB3 other worker green cards at 11,829, and if they get 10,000 a year, in theory, you should be able to run through that in about with a year's worth of visas, like leaving about 1,829. Meaning, it seems logical you might be able to get to. Why doesn't the visa bulletin say that, Sam? I guess that's the point I wanted to get to. Why doesn't the visa bulletin say that?
Because it's a dinosaur.
No, it's not a dinosaur. It's like a Sasquatch or a Bigfoot, Sam.
Yeah.
It's a mythical beast that I'm not sure whether it's real, and I'm incapable of understanding.
I understand. So that's the best answer we can have. And let's go into the next one here for Fort Myers. EB3 other workers been retrogressed since June of 2022 till 2023, July.
Yeah,
I see a little movement on August 23 visa bulletin. Thank you.
Yeah. Yeah. That's some more sort of.
And that's the and then one more comment. Do you think EB3 other workers there are any chance will be current in October of 2023 for priority date November 2021?
Yeah,
we just answered it.
Yeah. I mean, it seems like it's possible, but I can't help but look at the dates for filing and say, well, why aren't they forward?
Yes. You know? Surabi Swami, hi. I've recently received EB1A I-140 approval. Yes. My I-45 EB2 in CRP status.
Case remains pending. Yeah.
With advanced parole and EAD received. Priority date is April 2014. Interested in upgrading I-140 from EB2 to EB1A. Your insight appreciated.
Well, so Your I-140, I think I would maybe try to rearrange your brain a little bit conceptually here. You have 2 approved I-140s, it seems. One, oh I see. Okay, one I see. So an I-140 approved in the EB2 category with an I-45 attached to that from way back, and a recent EB1A I-140 approval. So fundamentally, there's 2 options. You do a transfer of underlying basis to move your I-45 from the EB2 to EB1 I-140, or...
My question to you, Brian, why did he not request the priority date when he filed for the EB1 I-140?
That's a great. You can't. Well, I think. Why didn't they request the transfer on underlying basis then?
No, the priority date.
Oh, well, you could. I mean, yeah, that's a very good point. I mean, you could have in that I-140 filing said, "Hey, I have a pending I-45."
Please, when you approve it, give me the older priority.
That is in USCIS TUB policy that you can do that. Yeah.
But it's automatically he has the older priority.
Well, yeah, he automatically has the older priority.
By law, it doesn't matter whether it's on the document or not. So you have today, by law, whether you see it on paper or not, an April 2014 EB1A I-144.
See, I think you're interpreting this differently than me. So I'm saying, like, you're answering the question of do I get the priority date? I mean, do I get the priority date? And I fully agree. For me, the question I'm answering is, I think that maybe I'm interpreting the question differently. Is how should I get my green card, my I-45 how should I get my green card to the EB1 category? And
you mean doing a transfer underlying basis of his I-45?
Yeah, that's
okay. I see interested in upgrading I-140 from EB2 to EB1A.
But this person already has 2 I-1. They're just. I guess the point I'd make is to rearrange your brain. You already have 2 I-140s, and if the issue is how do I get my I-45? It's either a TUB or.
So there's 2 potential questions. One. Is the priority date for the EB1 2014? The answer is yes.
Do I have to do anything? No.
The second one is if I have a pending adjustment of status with the EB2 I-140, how can I transfer or should I transfer that to EB1?
Yeah. What do you think?
It depends on the circumstances. I mean, if he's working for the same employer, and it's 1A, so it's self-employment.
Yeah.
So this is extraordinary ability, which means it depends on how it's drafted, but typically it's not tied to the job.
Yeah, so you can,
which gives him great flexibility.
Yeah, and they can still tub the I-45.
But now the I-140 is not current, I don't believe.
No, but they have the priority date. EB1 with the
2014.
The 24. Yeah, no, you're right. It's not current.
That's what I'm thinking.
It's not final. So.
It depends on what country. So if it's from India, right now it's June 1st, 2012.
Yeah.
January 1st,
January 1st, 2012. January 1st, 2012.
Yeah, but final action, dates for filing. Are they taking what are they taking?
They're not taking dates for filing for employment-based cases this month. Okay. And plus, in order to do a TUB, you have to have a final action date that's current as we read the policy.
As well.
So
so June 1st, 2012 is not current yet.
Yeah. So fundamentally, you can't do anything right now.
No, not yet. Yeah. Yes.
It's really wait until October is when the things. Interesting things will probably happen with the actual final action dates as well as with the dates for filing is when things really kind of open up.
Yes. All right. Sounds good. So we have a question here from Manas P. Hello, Sam and Brian. Yeah. Follow-up question. My spouse also has a green card EAD. Can she switch from 2 green card EAD to continue working while H-4 EAD extension is pending? So he's a gentleman that had an H-4 extending is pending and come back to H-4 EAD once approved.
This is a great question, and one I really like because it's a creative answer. And I think I just have to say no. Unless
they leave the country and come back.
Yeah, because the bottom line is use of that green card EAD is incompatible with H-4 status, and that's the problem. You're supposed to sort of maintain the status quo while you're waiting for your extension.
Yes. Yeah. Brian, take that one.
And this is I think it's a repeat of the question that we got there.
Go to the next one.
Yeah. what do you think about, from RC, what do you think about EB filing dates becoming current? There's a bipartisan letter asking for the administration to do it. So I will admit, RC, this particular one has missed my Google alerts, but
There's something that came out last week that was bipartisan to resolve things, but it is kind of looking at STEM PhDs and few other things. So we will have to wait and see how it evolves.
As Sam's talking, I'm just doing a little bit of reading to it. So I think this, for me, falls in the category of every time somebody, introduces a piece of legislation, it's those legislations and those letters are, a press release for somebody, and they're good promotional materials for congressmen saying what they want to accomplish. But with those laws, and the same thing with this letter, it doesn't happen until it happens. And I'd love to see it. It would make for a very interesting time in employment-based immigration. I'd love to see it happen. It's just I don't believe it until it happens.
Yeah. This one for you, Brian.
Yeah, I know. I was distracted by it. I like how Brian tries to explain the questions, all the moving parts and details till his last breath. I do have a reputation for talking a whole lot.
And we love that about Brian.
Yeah. Sam, you take this one. Now I'm feeling a little embarrassed.
That's right. TS. Hello, Sam and Brian. 1. If my H-1B transfer is approved, do I need to go outside the United States and stamp visa, or can I stay in the U.S. and work for employer B? Stamp visa expired, I-94 good until September 2026. The answer to that is you do not have to leave the country and come back to continue working. The visa stamp is only relevant if and when you leave and re-enter the U.S. Therefore, you could be in the U.S. in legal H-1B status for the next 10 years and transfer 10 times, and your H-1B expired 5, 8, 9 years ago. No big deal. As long as your passport is valid, you're in good shape. Yeah. Only when you travel do you have to renew your stamp.
Yeah, the popular metaphor is like, the visa is a key to the door that is the United States, I guess.
Yes. All right. Number 2, if I move and then EB visa date becomes current as per Congressman letter to USCIS, can my previous employer file my 485 even if no longer working for them, assuming they will be ready to do that? Well, can they do it? Yes, but that's not the only thing required for that to be a good faith filing. Most important thing is the filing has to be in good faith. And the good faith filing requires that there is a bona fide, meaning an honest, offer of employment to you from the company to give you a job on or before the green card is approved. And if that is available, then absolutely the prior employer can do it.
I think that's a pretty good answer for my book.
Yeah.
Make sure that's the one we're on. I think we're on this one.
Take that one, Brian.
From Manas P. If we heard a couple from Manas P. I'm on H-1B, spouse on H-4, also have EAD, AP, EB-2. If I travel outside the United States and come back on AP, do I have to change my status to H-1B to work on H-1B? What would my spouse's status be when I come back on AP? So I, as I sometimes do, am going to address these questions, last one first, and work my way backwards. So if you come back on advanced parole, you're considered a parolee. Look at what your I-94 says when you get it from Customs. Check it online. Always check your I-94 when you enter the United States. They screw them up sometimes, so always check. When you enter as a parolee, basically anybody who has status dependent upon you, like a wife and kids on H-4, those folks are going to effectively lose that status, because if you don't have H-1B, they're not on H-4. Their status is derivative to yours. There's no magic alarm goes off. Their I-94 doesn't magically get updated to say, parolee or period of stay authorized by the Attorney General, but that's just a practical, the way the law works, fact. Now, there's a policy, Sam, that was carved in stone because it's so old, 20 years ago, that says, hey, if you leave your current if you leave the United States while in active H-1B status with your current employer, you can't return on them with a valid advanced parole, we're still going to honor your H-1B status and even allow you to, or H-1B work authorization rather, and even allow you to extend it when you come back from the United States. So it might be possible to actually, if you want to get back on H-1B after returning to the United States after traveling on advanced parole, to file an H-1B to get back on H-1B status. I guess, Sam, a great question was, would you file an H-4 for that spouse as well, considering that, you know, de facto they were put out of status?
Well, he enters on advanced parole.
Yeah.
The spouse is no longer on H-4,
Yeah.
but has a valid I-94 unexpired.
Yeah, for H-4, yeah.
And therefore, she's not accruing unlawful presence.
Sure, I agree with that.
Okay, so she's not in legal status in the U.S., but there's no...
It's not a problem.
Well, it's a problem because it's illegal, but there's no penalty.
Well, because she has a, well, I mean, I presume the spouse has a pending adjustment of status as well.
Okay, if the spouse has a pending adjustment status, she falls on that, yes.
Yeah.
Yes. And therefore, there's not a problem whatsoever.
Okay.
But if she doesn't, then it's a problem.
Now, would you file that H-4 if you're filing? Would you file an H-4 with that?
So, I mean, there are scenarios in which the spouse doesn't have the adjustment, but yes, most of the time the spouse has the adjustment.
You're right. That's a very. I was ready to glaze over that fact. And but it's one of those great things for saying, you know, this is why this is just a nice casual conversation here. And if you really want to get, you know, the best understanding of your cases, pick an immigration attorney if you're choosing.
And you know,
talk to us. We're nice to talk to. All of us immigration attorney folks.
Yeah, and with the short answer, question and answer, we try to answer it and fill the gap sometime and make some general assumptions. Not everybody fits that, and therefore it's really critical that you guys consult with an attorney. But those are great questions, and that concludes today's session, by the way. Next Monday, 6 o'clock Eastern Time, come back with more questions. We'd love to answer them to you. You guys have a great rest